SJC-11511, Donald Thomas Scholz and others, v. Nikki Delp. SJC-11621, Donald Thomas Scholz v. Boston Herald and others.
Thank you.
Mr. Carter.
Good morning, Your Honors. May it please the Court. I would like to start by saying that there is no constitutional value in false statements of fact. That is from the United States Supreme Court in the Milkovich case and the Gertz case. The statements here in these articles were factual. On the first page of the March 16 Boston Herald, there was a large banner headline, "Pal snub, made Delp do it." The first paragraph of that article stated Brad was driven to despair after his longtime friend, Fran Cosmo, was dropped from the summer tour, the last straw in a dysfunctional professional life that ultimately led to the sensitive frontman's suicide, Delp's ex-wife said.
So you're basically saying that it is a question of fact what caused someone to commit suicide?
Absolutely, Your Honor.
You're saying that is susceptible of being proven false?
Absolutely, by a preponderance of the evidence. And in fact, it's done routinely in cases around the country, whether it is a...
In defamation cases?
In defamation cases, there are at least two examples where that has been submitted to a jury. That's the Rutt case and the McRae case. In McRae, the Third Circuit affirmed sending the case, a defamation case involving an allegation that a parent had been responsible for a child's suicide to a jury. And in Rutt, in Pennsylvania, the same essential allegation was made that a parent had contributed or caused the child's suicide. That was deemed defamatory, and it was sent to a jury. Obviously, within those decisions to send to the jury was the conclusion that a jury could find whether it was true or false. And of course, in cases elsewhere, in other types of civil cases where suicide is involved, that is routinely sent to a jury, whether it is a pharmaceutical product that may, an antidepressant, for example, that may lead to a suicide. That is submitted to juries in this district and elsewhere. We currently have cases involving NFL or NHL concussions that lead to suicide. Those are being litigated.
But your client, I take it, had the obligation to prove that at the time that Mr. Delp committed suicide, he was not thinking about Mr. Scholz.
We have the obligation to prove that the Herald articles were false. And the Herald articles said two things: that Tom Scholz, through alleged bitter band conflict that he perpetrated, according to the articles, caused Brad to kill himself, and that Tom Scholz's decision to terminate Fran Cosmo caused Brad Delp to kill himself. We can prove those false by a preponderance of the evidence based on Brad Delp's own written statements immediately prior to his death, both in suicide notes that he left and in heart-wrenching emails that he left concerning an incident of serious personal misconduct. There's no dispute that he taped a camera to the bedroom of his fiance's sister, and that was discovered. She confronted him. There followed 7 or 8 days of heart-wrenching emails between the two of them. He didn't want to tell his fiancée, this woman's sister, that he had done this. And he talks about, I've committed the most grievous sin, I'll never forgive myself. There was finally a confrontation between this woman, her then boyfriend, and Brad Delp on the day he committed suicide. There's testimony from those two that Brad Delp was confronted. The boyfriend was yelling at him, and Brad Delp was crying and saying, "I'm sorry, I'm sorry, I'm sorry." He then goes out, we know from the record of purchases, went out and bought the 2 charcoal grills that he used that night to asphyxiate himself. I believe that we are entitled to, Tom Scholz is entitled to put that question to a jury and ask the jury to determine whether we've shown by a preponderance of the evidence that it had nothing to do with Tom Scholz. And I might just add
And that Mickey Delp knew that.
that's separate. That is separate, because
Yeah,
that's
it's separate. but-
that is separate. What I'm talking about right now is whether we can prove that the allegations are false. Whether Mickey Delp knew it or whether the Herald reporters knew it, that goes to actual malice. We aren't saying that they knew about this, but as to Mickey Delp, we know from her own sworn testimony, she said in 2008 when she was deposed, "I have no idea if Tom Scholz had anything to do with Brad Delp's suicide." And yet, if the Herald's affidavit is believed, and at this stage it has to be believed, she went to the Herald reporter and said, "I do know." And it was Tom Scholz' conflict with the other former members. It was termination of Fran Cosmo. If she said those things knowing that she had no idea, then she is fabricating. She's also reckless because she knew from the suicide note that she had received and from the suicide note to her children, she knew that Tom Scholz had not been mentioned. The band had not been mentioned. Fran Cosmo had not been mentioned. Nothing about Brad Delp's, nothing about the band Boston or his professional life was mentioned in those suicide notes, which she had received. So for her to then go to the Herald and say it was the band Boston, it was band conflict, that is, I would suggest fabrication, but at the bare minimum, recklessness as to the truth or falsity of what she was saying.
But here's the thing, just because somebody leaves a series of suicide notes saying, this is why I'm doing what I'm doing, is that the same thing as not being able to have an alternative view? I mean, just because the suicide victim gives an explanation doesn't necessarily mean that's the only explanation, or that somebody else who has knowledge of that person and the events of that person's lives could form a different view of what really happened here.
It's a question. It's a classic question of fact, which is for the jury.
Fact or opinion?
Fact. This is something that is the cause of death or the cause of a suicide is fact, and it's submitted to juries to determine. That is something that juries do. Even if it were opinion, it's still actionable. Because as every court that has looked at the statement has said to this point, the implication that there are undisclosed facts,
Undisclosed defamatory facts.
undisclosed defamatory facts is actionable. And every court that's looked at it has agreed that the allegation that somebody has contributed to or caused a suicide is defamatory.
Help me with the undisclosed defamatory facts. What are the undisclosed facts that are defamatory? I understand that there are undisclosed facts, such as the incident with the camera and long-time depression and other things like that. But those are not defamatory facts.
Well, the implication of undisclosed defamatory facts are the following. You have the Herald telling its audience in an article at the same time that Mickey Delp has a private suicide note. You have the Herald describing to its readers that this woman is the mother of Brad Delp's children and the ex-wife. You have the article describing unnamed quote-unquote friends and quote-unquote insiders. The article is in the inside track.
But what are
which
the, I'm sorry, you're not answering my question about what are the undisclosed defamatory facts?
well, certainly, it was not disclosed the actual cause. They didn't know it. But
But what's defamatory?
what's defamatory is that there are facts in existence, this is what is implied, that support the allegations in the articles that Tom Scholz made Brad Delp do it. So,
Defamatory facts, I take it you would say about these years of dispute between him and the others, or defamatory facts about why Cosmo was dropped from the tour, or...
yes, and pressures that are not identified. So there's a reference to pressures, or there's a reference to Tom made Brad do the Boston stuff. There's reference, as Justice Botsford says, to these years of conflict. There's reference to the family relationships making it more complicated. In fact, Mickey Delp testified that wasn't the case. They don't talk about business within the family. So there were these sorts of general statements with the implication that there were facts behind them that the reader is not told. So what's critical in a defamation case is that the reader be able to determine for him or herself whether this statement is true. And the readers were not given that here. They were told by insiders who had private suicide notes, broad statements that essentially Tom Scholz, through his founding and control of the band Boston, caused this man, Brad Delp, to kill himself. They talked generally about Tom forcing Brad Delp to do the Boston stuff, years of conflict, but they don't give any of the detail. They talk about pressures. They don't say what pressures. In fact, Brad Delp was not forced to do Boston. Brad Delp came and went. He considered himself a free agent. He quit in the 1980s. In 1990, he quit again. In fact, Tom Scholz called him to assist in recording the next album. Brad said, no, I'm in the middle of another project. In fact, that project was with Barry Goudreau, and Brad Delp was not the singer on that album. He came back after that, before this potential tour in 2007. Tom Scholz actually sent Brad Delp an email, said, do you want to participate? I'm thinking about a tour, and I want to make sure that you're okay with it. Brad Delp says, yes, I just want a few days off, because he was going to get married to Pam Sullivan. And of course, Tom Scholz was happy to comply. So there were, in the articles, a statement about, factual statements that Brad was forced to do this, that there were pressures, and yet the actual evidence will show that he wasn't. So that's, I think, some of the undisclosed facts are how did he really interact with Tom Scholz? Was he really forced to do this? Were there really pressures? The evidence will show that there weren't, other than the ordinary pressure that one has from any job.
And so what you're saying is that the undisclosed defamatory facts were implications that the interactions between Delp and Scholz were bad, and that they're and it would portray Scholz as being the bad guy.
Absolutely the bad guy. In fact, that's how these articles were read. The articles were read as factual statements. They were, when folks who knew these individuals read them, they were extremely upset. Mickey Delp immediately, according to her testimony, called an individual named Paul Geary and said, I absolutely didn't say that. It's not.
To that point,
Sure.
I've been waiting to, maybe I just wasn't getting the point, but does it make a difference if we were to conclude differently with respect to Mickey Delp than with respect to the newspapers? For example, that what she said from her point of view was the rhetorical kind of hyperbole. Does that make
Well,
a
except
difference? Do they
if
both
she-
stand or fall?
if I understand, she did not engage in rhetorical hyperbole. If she had, then that might not be actionable. But she said, in a considerate way, days.
Take it as a hypothetical.
As a hypothetical, if somebody said something in a dramatic, hyperbolic way, that might not be actionable. So hypothetically, if Mickey Delp had said to the Herald reporter something along those lines, and that she may not, there may not be a claim against her, there would be against the Herald if they reported it as news. Not in a hyperbolic, dramatic way, but they reported this is a fact that she told us. She has a suicide note. She's an insider. She's lived with this guy for years, knows all the players, and now we're going to tell the world that the consummate insider is saying what really did it. And people believed it. It was reported by other media outlets, a company named Launch Radio, which feeds other radio stations around the country, picked up the Herald story and relayed it, saying that Mickey Delp said it was Tom Scholz. The internet bloggers picked it up.
Well, that's interesting, but I mean, you make the comment somehow that this is being reported as news, but I mean, this is a gossip column.
It's a news column, and it does report about.
In the same way that the Inquirer is a news.
No, I think they describe themselves as a news column in the depositions. They reported this as news. They reported this on page 1 of a major metropolitan paper. That is not where gossip and opinions are put. It's where facts are put, and they were read as factual. And most importantly for the analysis for this court is, can they reasonably be read as factual? Or I should say, is the only reading that they are pure opinion? Because if there's any way to view these articles as reasonably conveying factual statements, then it is a question of fact for the jury. And every court that has looked at these articles as a whole, whether it's Judge Kratzley, Judge McIntyre, the appeals court, has said they can be read reasonably as blaming Tom Scholz, and hence they are defamatory, and on that basis should go to the jury on that issue.
They didn't, what about the issue of whether or not they could be seen as anything other than opinion?
Judge McIntyre.
Well, Judge McIntyre, she also found that they were appropriately read and reasonably could be read as factual. So she did not conclude that they could be read as pure opinion. However, she concluded that even if they can be read that way, it's not actionable because you cannot prove the cause of suicide to a certainty. As Justice Spina said, well, how do you know if a thought at the moment of in this case, asphyxiating himself, whether a thought crossed his mind that Tom Scholz was such a bad guy that I'm going to actually go through with this, that's not the burden. It's whether we can prove by preponderance of the evidence to a jury that the real cause was all of the evidence we have from Brad Delp, from his own words, written words that I've described, that the real cause was his own personal misconduct, and from his suicide notes, a person who'd been emotionally depressed and suicidal since he was a teenager, long before he knew Tom Scholz. So that is a question that respectfully believe that Judge McIntyre got wrong. And it goes back to the original question from Justice Link. Can you prove it or not? There is, just this weekend, the story about a woman who committed suicide through assisted suicide. Can we not say that we know and can prove what caused her to kill herself? She has said it over and over on news shows repeatedly and publicly. She has a terminal illness and wants to and has ended her life. So the point that the conclusion that Judge McIntyre reached, that it's not provable, I think that example is just one example where it's shown to be incorrect.
Just suppose in that example, and it has nothing to do with this particular person, but suppose a relative had a dim view of her relationship with, say, her husband, and said that, in fact, there was a different explanation for this. Is that actionable?
Yes. And that's exactly our point. That we should then, that person, whether it's a husband being blamed for actually having been abusive for decades and having been the real reason, that somebody now comes forward with that horrible allegation, that person should be allowed to present it to a jury and clear his name, which is what Tom Scholz is asking for, an opportunity to clear his name before a jury to show that, in fact, he wasn't the one responsible for it. And it's important that he have that opportunity because he actually asked the Herald for a retraction. All of this information came out about the personal misconduct and what was really going on in the last days of Brad Delp's life. The Herald has yet to publish it, which is another piece of the evidence of actual malice. Under the Murphy case, if a reporter learns of significant information that actually gets to the truth and demonstrates that the original story is inaccurate and they do nothing with that, the Murphy court says that's decisive evidence of actual malice. Of course, there's a lot of other evidence here of actual malice, including destruction of the reporter's notes.
Yeah, Mr. Carter, I'm sorry, your time is up.
Thank you.
Thank you.
May it please the court, I'm Kathy Weinman, counsel for Mickey Delp, the former wife and the mother of Brad Delp's children. Although they'd been divorced for 11 years, they remained in frequent touch and were very close friends. In fact, they were so close that when Brad died, he left one of only 4 personal suicide notes for Mickey. 6 days after his death, and still grieving for the loss, Mickey agreed to a brief telephone conversation with a Boston Herald reporter. And in that conversation, she shared with the reporter her views about Brad and his mental state. Although Mickey never mentioned Tom Scholz's name or mentioned him by his position, Tom Scholz sued Mickey for defamation 7 months later. This court has stated time and time again that summary judgment procedures are favored in defamation cases because even requiring a case to go to...
Figures,
Pardon?
particularly for public figures.
And
public
particularly
officials.
for public figures that we have here. Because requiring a case to...
Mickey Delp, a public figure?
Mickey Delp is not a public figure, but Tom Scholz is. And I would submit, Your Honor, that Brad Delp was as well, and there was a lot of public interest in this particular event. I want to start, Your Honor, with the issue that the court raised first. Even though Judge Kratzley expressly didn't reach the issue of opinion because he rested his decision on 3 other independent grounds, I think there is absolutely opinion provides a basis for affirming summary judgment here. This court has made clear that only verifiable statements of fact and not opinion can be the subject of defamation claims.
Do you take the position that, as Judge McIntyre did, that you could never have anything, since no one will ever know why somebody else commits suicide, it's always going to be a matter of opinion, which seems to be where she comes out?
I think that was her rationale. I would state it a little bit differently.
My
but
question
yes.
was whether that's your view, or your view is whatever might be true in some ultimate sense. In this case, reading the article or articles, it's clear that what is being expressed is her opinion. That is your client's opinion.
It is absolutely clear that what is being expressed about Brad's mental state is her opinion. This court, I think in the King case, provides very good guidance on what is opinion in the context of a defamation case. In that case, the court held that statements about someone's motivation is opinion, and it very clearly distinguished between opinion for purposes of defamation cases and opinion and motivation in cases like criminal matters, in which motivation is treated as a question of fact. Under the First Amendment and this court's precedents, opinion is protected speech, even when it's wrong, even when it injures the reputation of others. We provide protection for those statements.
So could you say again, which cases stand for the proposition that motivation is, in defamation cases, is not a question of fact as it is in other types of cases?
That's the King case.
That's the
Your
King
Honor,
case.
King versus Globe. And in that
That's what you
case,
take King to mean.
pardon?
That's what you take King to mean.
Yes. Yes. King, in that case, Your Honor, the court affirmed summary judgment for the defendant in connection with a statement that the governor's legislative actions on racing legislation was motivated by loyalty to an associate who was a race promoter rather than to the public interest. And in that case, the court upheld summary judgment for the newspaper. Other cases are in accord. Lyons versus Globe.
Are you referring to the element of malice when you talk about that the cases that say that in the libel context, malice doesn't refer to a person's motivation in making a statement, but whether or not they believed that the statement they were making was false?
That provides an independent basis for affirming the summary judgment decision of Judge Crassley here. But I think opinion, the statement about Brad's motivation in committing suicide can't be subject to defamation for an independent reason, in that it is an opinion of Mickey Delp's. But I do think that cases like Lyons versus Globe, in which this court reversed summary judgment against the defendant on statements that a police union was motivated by its desire to help a particular candidate when it picketed the Democratic State Convention. Cases like Cole versus Westinghouse, in which the court directed a verdict for the defendant on statements that the plaintiff was terminated because he had a history of bad reporting, are similarly on point.
With respect to, okay, take that. What do you say, though, to Mr. Carter's recitation of, arguably, undisclosed facts on which that opinion may be based? That would, I take it, be actionable if it's accurate.
It's actionable. It would be actionable if Mickey Delp's own statements implied other undisclosed defamatory facts. And there is nothing either in the record or anything that Mr. Carter stated that suggests that she implied undisclosed defamatory facts, or that any of the facts that were disclosed were in fact
Well,
defamatory.
let me just take one example, and I'm not going to get the words exactly right, but it's the, it's the statement about Goudreau were family, and it caused problems in the family, or I forget exactly what was said, but that's suggesting a lot of other conversations and things going on. I mean, it's implying a lot
So
of
what Mickey said was that Barry, Goudreau, and Sib Haitian are family, and the things that were said against them hurt. That's what she said. The factual part about that is that Barry and Sib were family, and that there were things said about them. There's nothing that says that it was Tom Scholz who said anything against them, or that, and there's nothing in the record that suggests that that in and of itself is defamatory. It is, as Mr. Carter has said, the drawing a connection between the facts and Brad's suicide that are alleged to be defamatory. And our position, and I think the position of this court in its precedents, is that those are pure opinion and can't be subject to defamation claims.
You don't think that there's something to the argument that because she was the ex-wife, that she was privy, and of this family relationship in connection with Cosmo? Was it Cosmo?
No, it's Goudreau.
Goudreau. Goudreau's wife. That she had the view of an insider and had facts that were simply not, that would allow her to form this opinion.
I think that the facts on which her opinion was based were in fact disclosed by her. And I also think that the context of the statement 6 days after her death, somebody who was close to Brad Delp, actually goes in the opposite direction. As courts have recognized, statements made in emotional grief actually are likely to make it clear to the audience, to the reasonable reader, that those are opinions and not statements of fact.
Just on that point, there was some suggestion, I apologize, but in the record that, or in the briefs, I haven't looked at the record, that she actually, in substance, volunteered to this. She took the phone, said, I want to speak. So this grief stuff, I just don't know how that plays out, if that's a factual issue or not.
I actually don't, it's not a factual issue. It was not disputed that that she was crying, and that she decided to take this call because she wanted to stand up for Brad. So that I don't believe is disputed. I think a lot of, I want to also say that the actual malice issue that Your Honor raised in your question also supports summary judgment here. There's no evidence whatsoever that Mickey Delp herself doubted the truth of her statements, or that she had a high degree of conviction of their probable falsity. And the absence of that evidence, too, is another grounds for sustaining summary judgment in this case.
Thank you.
Thank you.
May it please the court, I'm Jeff Robbins on behalf of the Herald parties. First, there are 6 things that make Mr. Scholz's defamation claim so unusual here. First, Mickey Delp didn't even mention Scholz. Second, the Herald did not say that Mickey mentioned Scholz. Third, the Herald articles contain no statement that Scholz was the cause of Delp's decision to take his life. Fourth, the Herald articles do not state that anybody said that Scholz was the cause of Delp's decision to take his life. Fifth, and this is something that Justice Lenk has dealt with in the Netherwood.
Well, If you just take the headline on the March 16th, is it? That's, I mean,
Yes.
that's on the front page.
Yes.
X says Schultz, I mean, it says it right there.
Doesn't say Scholz. It does not, Your Honor, with all respect. It
It's-
says that the firing of, or the fact that Cosmo, that Mickey Delp had reported her view, which in fact was her view, which he's confirmed was her view, that Cosmo not being in the band was the last thing. So
This is the one that said pals snub?
that's exactly right. So it's not a statement about Scholz. It doesn't mention Scholz. It's reporting accurately, conceitedly, Mickey Delp's view about Brad Delp's emotional reaction to Cosmo not being in the band.
Who's pal who?
The pal is Cosmo.
Cosmo.
Is Cosmo. No, it's not Scholz.
The snubber is Schultz.
Okay, but
Clearly so.
it's the Herald accurately reporting Mickey Delp's view of her husband's, or former husband's, reaction to Cosmo not being in the thing. The Herald affirmatively published, this may have gotten lost, but it's something that Justice Lenk focused on in the Netherwood case, a raft of facts and quotes, including from Delp's suicide note, from his fiancée, from his friends, and from Scholz himself, all through the 15th and the 16th articles, saying that it was not Scholz. The suicide note took responsibility. It was his fault, he said. It reported the fact that his fiancée had said he was feeling unhappy. It reported friends saying that he was a sad person. It reported several people saying that he and Scholz were the best of friends or remain close friends. Surely a generous assessment given the facts. With respect to the Cosmo, it went out of its way to affirmatively quote Scholz, saying that it was a group decision. So there was nothing in there that reasonably led to the conclusion that the Herald was even expressing an opinion that Scholz was responsible for Delp's death.
Was this a news article?
These are gossip columns. In fact, Mr. Scholz has called them gossip columns.
Listed on the front page of the paper and you call it a gossip
Well,
column?
it is, the inside track is a
Well,
gossip
it may
column.
be, but once you treat it that way, is it really fair to say it's just a gossip
Well,
column?
either way it is, I mean, it is, as Mr. Scholz has said, a gossip column, and that's significant only because Oxford Dictionary has defined gossip as details that are not confirmed as being true. But I would say that where Scholz was unable to identify and the court was unable to locate a single false defamatory statement of fact by the Herald of and concerning Scholz, let alone a statement that Scholz was culpable in Delp's death, and in fact the court ruled there was no such statement. So what this is a theory of insinuating overtone. A public figure making a defamation claim because he says that in the aggregate, a collection of facts, none of which is actually of and concerning him as a matter of fact and defames him, gets you to a defamation claim based on defamation. Even if you could do that.
Are you, well, it wasn't, I mean, Judge Kratzy actually wasn't ruling on your claim, but is that your main point, that it's not of and concerning Scholz?
No, I'm not making that argument at all, not at all.
Okay.
I'm saying that the first argument we made in our brief was that under the Mahalik case, you can't, a public figure under Times versus Sullivan can't maintain an insinuation in the aggregate claim, because if there's no actionable false statement of fact in there, he can't proceed. But let's assume for the moment that you could. The exact quote, Justice Lenk, from King is, quote, "While in a criminal case, the motive or intent of the defendant in performing an act is ordinarily treated as a question of fact, in a libel action, a statement about a public official, but it applies to public figures, motive or intent is ordinarily treated as a statement of opinion." And Justice Gantz has made one of those most succinct enunciations of that, but this court has said it several times. No such, on the question of objective verifiability, no such objective ascertainment is available when the question is whether one thought something or did not. Now, here Delp was a public figure, and it was a matter of public concern. But we're several layers of
Can I
conjecture.
just stop you for that?
Sure.
So the argument then as to the cases in whether in other areas of tort or in the criminal law where jurors are asked to determine the cause of someone's suicide, you're saying those cases have no applicability?
Well, I'm not saying it. I'm saying that the court has said it so. But you don't even need this. We don't even have a King situation. The King court said that the motivation of a public figure is not an issue of, is an issue of opinion for defamation purposes. But we don't even have that. We have several layers of conjecture beyond that. We have not a live person, not a living person, not a plaintiff, a party in the case. We have a decedent. And the question is...
But you would always have that in a case involving the cause of suicide.
Well, so we have the question of, yes, that's right, and that's one of the reasons why Judge McIntyre was correct.
No, I'm just saying, so you're just, I'm asking you to distinguish the case law that says that it's, you know, that's actually a matter of fact that can be proven.
I guess I'm saying that in the King case...
Other than in libel cases. And I'm striving to understand the rationale why libel would be carved out, so that this would be just a matter of pure opinion when it's considered fact in other kinds of contexts.
Well, it's not merely the cause. I mean, I'm saying that, I guess I'm beginning by saying that it's the King court that has said that, and there are reasons for it. But here, we have somebody who, the question is, what thoughts were in someone's mind at whatever moment it was, or series of moments it was, that motivated him to take his life? And as Mr. Scholz conceded, and as Judge McIntyre found, it's even more speculative than that, because, and I think Justice Spina, you referred to this, the issue would be Mr. Scholz would have to prove that the thoughts of Mr. Scholz, or his upset at Mr. Scholz, or his humiliation, or all of these issues about Boston were not in his mind, which is surely a layer of conjecture beyond that. But it's even more impossible to prove than that, because on this summary judgment record, it was undisputed that Brad Delp had told about 20 separate people, including his doctor, 6 weeks before he took his life, all before this camera incident, by the way, that he had told them that he in fact was despondent, anxious, depressed, humiliated, and feeling abused.
That goes to the question, it seems to me, of what kind of proof you have, what kind of evidence you have one way or the other. I'm still trying to get at why it is in other kinds of cases thought to be a provable matter, and that in defamation cases, in libel cases, you're saying we've decided otherwise. What is the pivot point for that?
Well, it's not the cause. It's whether somebody, it's not the cause of something. It is
why someone committed suicide. Isn't that what we're talking about?
Whether or not thoughts of these issues were in Brad Delp's mind at whatever moment it was that he made the decision to take his life, or a series of moments, assuming, by the way, that this was a rational process in any event. I mean, it requires you to engage in all of these levels of conjecture.
I think the difference between defamation and, let's say, murder on the motivation question is, in defamation, you're weighing fact versus opinion. In murder, an opinion can be a fact. It's fact versus law. So it's comparing different things in calling, the fact is the same, but what they're being compared to makes a big difference, I think, in terms of why one may be called a fact that can be proved in a criminal case, but not necessarily in a defamation.
Yes, I should say there are no cases. The Pennsylvania cases that are referred to are not opinion cases. They're cases about whether or not it is defamatory to say it. Very different, as Justice Lang pointed out, than opinion. There is one case that we have all been able to find that is directly on point. It is, of course, not controlling. It's the Gassick case. It's the Eighth Circuit case affirming summary judgment. And there, you actually have what you don't have here. You have somebody saying, person X, the plaintiff, caused that suicide. That's what you have there. We don't have that here. But there, the Eighth Circuit, this is a 2012 case, said it's classic conjecture. You can't possibly know. It's nothing more than surmise. 2 quick points with the court's permission. There are no implied, the Herald, Mr. Scholz has been unable to identify a single implication that the Herald was in possession of some undisclosed defamatory fact about him, that it withheld, that it didn't disclose. And Judge McIntyre was correct to so find. In fact, it's more than that. Judge McIntyre pointed out that the articles are the disclosures. Insofar as the Herald can be said reasonably to have insinuated the view that Scholz was responsible for Delp's death, and it did not, it provided the disclosed facts. They were the Mickey Delp quotes in the 16th.
So let me just ask you that. Are you distinguishing your client from Mickey Delp, in the sense that, are you saying that whatever might be the case of undisclosed facts underneath her opinions as quoted or described in the article, there are no separate undisclosed facts that are underneath you, or are you and Mickey Delp in one and the same place in this?
I guess the only, I'm not sure how to answer, only to say that the Herald, insofar as the Herald article can be said to express the view that, assuming it were not pure opinion, assuming it was impure opinion, the second level opinion, the Lyons versus Globe line of cases, then the Herald, as Judge McIntyre properly found, it disclosed the basis. It disclosed the quotes, and by the way, it also disclosed all of the contrary facts in the article and the quotes. The statement by Brad Delp that it was his responsibility. The statement by his fiancée that he was feeling unhappy about himself. The statement that they remained the best of friends. The statement by Scholz that Brad Delp was perfectly happy with the Cosmo situation. All of that is fully disclosed, and so the reader can make a decision for herself or himself whether or not the Herald is even expressing that opinion, an opinion that Scholz was responsible, and if it was, if they do think that they were expressing that opinion, whether it's a valid opinion. So that's the classic Lyons versus Globe line of cases. The last point, with your permission, is actual malice. The standard is, as Ms. Weinman says, clear and convincing evidence, and Justice Spina, I think, is the last person on this court to write a decision on that in the Hip Saver case. Clear and convincing evidence that the Herald published its articles with a high degree of awareness of their probable falsity, when it is undisputed, although Judge McIntyre didn't have to reach these, she made subsidiary rulings which mandate affirmance on that additional basis. She ruled there was no dispute of fact that the Herald reported the views about Brad's mental state that were provided to it, as it's entitled to do under the First Amendment, and moreover, that those views were in turn based on what Brad Delp had told them or they had observed. Under those circumstances, we submit, he can't meet that daunting burden of showing such clear and convincing evidence, let alone, and this is something which was a subject of Justice Lenck's decision in Netherwood, where we disclosed all of these facts that cut the other way, which cuts sharply against any conclusion that we entertained serious doubts about its truth or falsity, or more, published having a high degree of awareness of their probable falsity. So for 4 reasons, we submit that summary judgment in favor of the Herald should be affirmed.
Okay, thank you.
Thank you.
All right.